Okay, welcome everyone. Ida, if you can stop sharing your screen so that they can see me. Welcome everyone to Sestronow's Workshop Wednesday. Welcome to another exciting workshop, where this is going to be educational as well as a little fun, a little different. I just heard that we're going to have prizes tonight, but before we get started, I just want to update everyone. If you're new to Sestronow, I just want to explain a little bit about who we are, what we're about. So we're an international women's empowerment organization throughout the United States and in 35 countries. We have actually recently launched the first social media app for women. On that app, you can connect with like-minded women. We call each other Sestras. Sestra stands for Sister in Slavic Languages. And also we have a marketplace where you can actually find our host tonight, the trademark attorney that's presenting. You can find her for her services, as well as many other women business owners on our marketplace, which houses only the products and services of women-owned businesses. So if you're interested in downloading the app just to have a safe online space to connect with other women, to do challenges, to get your event links, as well as to shop with our Sestras, go to www.sestronow.com to download the app, or the Google Play Store or Apple Store to download it. So without further ado, let's get started with this exciting workshop on trademarks. Learn how to protect your business. And I want to introduce our host, Ida Ivowi, tonight. I met her, as you probably know, I'm an attorney, New York. Annette Hicks-Gill and I met her at a event that was for attorneys in Queens, New York. And yes. We connected, and I'm so happy that she became a part of Sestronow. And again, you can find her on the app. So without further ado, we're going to go ahead and let her start this wonderful presentation.
All right. So good evening, everyone. I'm going to try and match that upbeat. I know it's in the evening and everybody's tired, but you know what? I'm going to try and make this a really, really interesting event for us. So it's going to be interactive. I'm not going to be the only one talking all night. So I'm going to ask questions. We're going to play quizzes. So, get ready and let's get started. So what I termed this evening, I said, if you think it, so basically, if you think about it, you think you own it, or you know you own it, then you need to protect it. So think about that. If you think it, so in which case you are thinking about it, whatever it is, then you own it. So in which case you've done something about it and you believe it belongs to you. Now, what next do? You have to protect it, right? So that's what this is all about. And that's the theme of tonight. So without further ado, we're going to go ahead and get started. So who am I? Well, as she already told you, my name is Ida Ivowi. I am a New York, New Jersey, Texas, Maryland, and Washington, D.C. licensed attorney. I practice intellectual property, obviously, family law, estate wills and planning, and I also do some property law as well as transactional law. So for those of you who own businesses, we can all help. Just as our lovely host introduced, did say this is the
She's muted.
Okay. Can everybody hear me?
Yeah, we can hear you now.
Okay, I'm sorry about that. Technical difficulties. Okay. All right. So I'll repeat that. Just that my name is Ida Ivowi. I'm not going to say everything I said before because that will be repetitive. But anyway, I own TELOSLEX LLC. That's the only thing I didn't say before. Our headquarters is both in New York and New Jersey. So I'm going to move on to the next slide now. And so this is our first quiz, and I'm going to ask our host to please bring up polls. I would like each and every one of you to take part in it. So could you let us know if you do see the polls on your screen? Okay. So you are going to get a poll. And for this particular quiz, I would like you to identify by clicking on the name. So I'd like you to identify who owns these 4 marks here. So if you could just click on your screen, on your poll, your selection. I don't see anyone clicking. Do you all have the polls?
I need mine.
Sorry?
Can you guys see the poll?
It should be here.
Question number 1, I do see it. Let me just see if I can do it.
You can see the
said-
poll, but it's a whole bunch of questions, so you have to answer all the questions
No,
before.
she's on question
just
number 1 right now.
Just question number 1.
Yeah, it
So
won't let you submit just question number 1, is what I'm saying.
Oh, okay.
How is
In-
that possible?
Well, it won't let me do
Can
it,
you
so I'm
share it
sorry.
again? Can you share it again? We go can't see it.
Okay, let me relaunch it. Sorry about that.
Okay.
Okay.
If not, maybe what we can just do is you see the options on the screen and you could just type in the chat.
On the
Okay,
bottom,
let's do that.
on the bottom of the screen, go all the way, you know, where it says mute, start video, slider all the way to more, and then it'll bring up polls, quizzes, and then you can get it like that too.
Oh, you mean everyone else can do that?
Yeah. That's what I
You
just
have
did.
yours up? Okay.
The way it says more here, you see polls there. And
See if you can pull it up, everyone. I'm trying to see if I can answer this question. Who do these marks belong to? I'm gonna say, it won't allow me to pick.
Okay. I think in the interest of time, let's just start entering it in the chat. That might work. Unfortunately,
Okay.
Zoom disappointed us this evening. So
Yes.
yeah, it's okay.
I don't know. How does it, why does it, oh, why wouldn't it let us answer? Interesting.
Okay.
All right.
I'm-
So in the chat,
I'm gonna put the options up here again. So, and I can read the options out. So, the first option is Chanel. The second option is Gucci. The third option is Coach. Fourth option is Hermes, and the last is Tommy Hilfiger. So, these 4 marks here, if you can identify who they belong to. So I do see someone has answered 3 of the 4.
you have to pick one though, right?
No, you're answering all 4. Who do all the 4 marks belong to?
Oh.
Someone has answered 3. I see someone's gotten all of them. Yay, there's going to be a prize at the end. Keep trying, keep trying. I actually prefer this because now I can see who wins. Okay. Has everyone had an opportunity to respond?
I did. This is fun.
Okay. All right. So we'll just continue because at the end, I'm going to collate all the answers. But I think everyone who's voting has voted. So at the end, we're going to look at the answers. So now we can start with the introduction to trademark. So I'm going to use the restatement third section 9 to make sure that I'm giving you guys the recent and correct definition of what a trademark is. So here it says a trademark is a word, a name, a symbol, device, or any designation or combination So such designations that is distinctive of a person's goods or services and that is used in a manner that identifies those goods or services and distinguishes them from the goods or services of others. Now, it's a very long-winded statement, but all it basically says is that if you have a word, a symbol, a device, a sound, or a combination of those things that I just mentioned, and you use it in such a way that you can distinguish it from any other person's word, symbol, device, that is what a trademark is. So remember, we're talking about distinguishing one item from the other. So think about the last exercise you just did. You saw Gucci, you saw Hermes, you saw Louis Vuitton. But how are you able to distinguish between all of these marks without even seeing the name? Think about it. So you see, you've known these items for a very long time. So I didn't tell you who they were until I brought the answers. But prior to that, yes, design, sorry about that. Prior to that, once you saw it, you knew it, right? So, and that's because Gucci has been able to distinguish its mark from Chanel, and Chanel has been able to distinguish its mark from Louis Vuitton. So now that distinction and that recognition of that mark is what is trademark is all about. So I'm going to continue. And if you do have any questions, please feel free to stop me, although I've allowed for questions at the end of the presentation, but you can just ask me any question. So what is the principle behind a trademark? Why did the US government decide, okay, we are going to give people trademarks, right? There had to be a reason for it. So what the government was trying to do was prevent consumer confusion. And I'm going to ask you, what do you think consumer confusion is? Who can tell me? You can unmute yourself and just tell me what you think it is.
When one company looks like another company and a customer goes to a company thinking they're someplace else?
Exactly. That's exactly, as a matter of fact, that's exactly what it is. So what the government is trying to do is make sure that if you feel you've gone to a particular company to buy something, you are buying from that particular company. You're not buying from some other person. So the government cares about people who have taken time to make products, build the quality of the products in such a way that they're able to market it and people like it and come and buy it, rather than anybody being able to just manufacture the same product and then diminish its quality. So the government is really, 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 really invested in making sure that the consumer is not confused. So notice there's something that I haven't talked about. I've only said that the government is trying to make sure you're not confused about what you're buying. I haven't said anything about you making sure that your product is unique, right? So we're not talking about uniqueness here. I haven't said anything about you ensuring that your product has use. I haven't given that distinction. All I have said is that that product has to be distinguished from other people's products. Okay, so I think at this point we are going to have a little quiz. Now, can you identify these words? And you have to be living under a rock if you can't. So I'm going to wait for you guys to enter the answers here. In your chat again, please. I don't see any responses. Okay, I've seen one. Yep. Yep. this one is fairly easy, right? I mean, if nothing else, we should all know Amazon, even though they keep changing their mark, right? We should all know Amazon. If you drive, you know Waze, even if you don't drive. And then WhatsApp is, everyone knows WhatsApp right now. So good job, guys. We're
You're
able to.
telling you're telling everything. So how are they gonna compete?
No, because I'm looking at it, I've seen the answers already. Everybody's answered, right? So I've seen the answers already. So I have it here. So I'm only talking when I see that everyone's answered, basically.
Listen, I didn't know what that other one was, that was thing, because I don't drive.
Oh, okay. So okay. Sorry about that. Okay.
It's okay. I learned something. It's okay.
Yes. Okay. So I'm gonna ask a question, and I really do need everyone to try and chime in. I'm not forcing you to talk, but to make this a little bit interactive, let's try and give me some answers here. So, what do you think will happen if people are allowed to freely copy other people's products and work? I mean, why? Why? Okay, yeah, infringement. Okay. What? Think about it. I mean, why should we allow some people have the authority to say that the next person can't copy what they've done? So why are we saying that it should just be unique to you?
Because it's just like to me, it's just like stealing anything. It's just like taking someone's car, right? Yeah, for lack of a better word, like intellectual property, they're saying in the chat, but it
So
should be.
let's think about it on the positive and negative side, right? So what are the advantages and disadvantages is probably what I'm trying to say is what are the advantages and disadvantages of having a trademark or letting people say, oh, this mark is mine, and so you can't copy it. So yes, we know infringement, intellectual property, we've talked about stealing money, loss of revenue, but what else? I mean, is there nothing positive about not giving people trademarks?
Something positive about not giving people trademarks,
Mhm.
meaning allowing everyone to use it freely.
Yes. I mean, yes. So why is copying such a bad? I mean, can't copying be something positive?
Well, I mean,
Go ahead.
I,
I'm sorry,
I,
Connie.
I was gonna say that after a certain amount of time, especially some copyrights are become free in public use and everybody can use it. But I think when you have it, you have the time to be able to either recoup all the investments that you made into this. So it allows you to be able to get back that revenue, and then after a certain amount of time it becomes open for everybody else, but gives you a chance to to not let everyone, so that is not a positive thing in the beginning, but it's positive for the person in the beginning, because most of the times we're putting in a lot of time, money, or whatever to develop this, and we see this all the time when we look at things like Samsung and Apple and the war, right?
Yeah, that goes on. Yeah.
Between that. And then but the positive is after the time is gone, and everybody else can come in, it can reduce the cost of things for everybody else. And that's the only kind of positive I can see.
So piggybacking off what you just said with Apple and Samsung, right? So that competition, what does it bring? What happens between Apple and Samsung? Think about it.
Advertisement? Well, free advertisement? That's what
Well, apart from advertising, what's the positive thing that happens from that competition?
It's healthy. Yeah.
Yeah.
Maybe
It's a
wider
healthy
markets.
competition.
Wider markets can be, when
Yeah,
you're allowed to compare wider, you have a wider market.
So you have a wider market, you have healthy competition, You
Right,
also have a higher quality of product though, because one is trying to up the other, right?
No, I
So for
got you.
example, we say the picture quality in Samsung is next to none, right? Compared to the picture quality in Apple. But then Apple, with each release, keeps trying to improve the camera quality, right? So if you take a picture with, say, a 14, or I'm sure even the 15, compared to if you took a picture with an 11, is not the same. Similarly, with Samsung, every new Samsung they bring out, the picture quality keeps improving and improving. So there's that healthy competition. So most of, if not almost everything you've said is actually what we're trying to say. So consumers can buy the cheapest one. So basically it can become affordable. It diminishes the incentive to produce high quality products. So when you allow everybody copy, then what's the point, right? Somebody said, loss of revenue, someone's stealing my money. And then it creates a market for lemons. So what do I mean by that? If, for instance, you went out and you wanted to buy a car, and you, as far as you're concerned, you're choosing to buy a Mercedes, right? So you buy the Mercedes and you're driving down the highway. I don't know where you guys are, but any highway, and then the car stops. Now, first of all, you're wondering, I bought a Mercedes. Why is this car stopping? And then you're standing on the highway by a Mercedes that's not working. I mean, think about that. Think about even the emotional, the emotional thing you have to go through, that you spend all that money buying a Mercedes, and then the blooming car dropped you on the highway, and then you're standing on the highway and people are watching you and thinking, why is she standing on the highway, a car not working in a Mercedes? So think about all of that. So that's now diminishing Mercedes quality in the first place, right? So, and you would not be happy about it. So I want to talk about, some of the key interests for trademarks. So we've already talked about, consumer confusion and fraud. It reduces consumer search costs. So say, for instance, if you wanted to buy, and I'm going to go pretty high end, if you wanted to buy a Birkin bag, for example, right? And I don't know how much they cost, but let's assume that you wanted to buy a Birkin bag and you went and bought a Birkin bag. You're not going to go all over the place searching for that Birkin bag, because you know exactly where to go to buy it, right? And then you're assured that the amount of money you spent buying that bag, right, means you bought a Birkin bag. But think about it. If you had to spend time going all over the place to make sure you got the authentic Birkin bag, how much time would that take you? And how much money would it cost you going all over the place, right? So think about it that way. It encourages people to be inventive, to keep consistency in their brand. Again, because we can jump to Birkin again. If you buy a Birkin bag, you're buying a Birkin bag, you're not worried about if it's going to be something else. It prevents free riding. So even though some people do free ride, but it tries as much as possible to prevent it. And then it encourages competition. And finally, it basically makes us a producer-focused society as a whole. So what that means is people grow up with ideas and put those ideas into fruition. And so we start to get different things. So think about it, if we never had an Apple. I mean, it's not like the world is going to end. Think about what your phone does for you now. Somebody thought about that. So those are the kind of things that you should think about as to why we have interest in trademark. So we're going to, did anybody hear that? Unfortunately,
I didn't hear anything.
unfortunately, our sound feed is not working. I wanted to play two different sounds for you to see if you'll be able to distinguish it.
Let me see if I can play. Let me see if it works.
Okay.
Do you hear that? No?
No, I think
All right. Okay.
was blocked from playing sounds. So we're going to leave that, and then we're just going to go on to what is the scope of trademark, right? So as most of you have mentioned already, trademark is a form of intellectual property. You know, it's what I need you to understand. It is not your ability to protect first, right? It is more about preventing consumer confusion. It's more about the use, how much use you have in the market and how much people are able to identify your brand, your goods, and your services. It really isn't about you being the first person to produce something and therefore protect it. So that is patent. This is different, completely different, right? Now, in this case, for example, we know that Taco Bell, once you see Taco Bell, you know it's a Taco Bell. When you see that mark, you know it's Nike. Same thing with Coca-Cola. All of this is what we call trade dress, right? So because these brands have been dressed in this manner, anytime you see it, you know it is what it is. So you know it is KFC, you know it is Coca-Cola. You don't need to even be told what the Nike, it doesn't even need to have Nike written on it for you to know that it's a Nike, right? This is because this dress, it's been used over and over and over and over again. So we basically know what it is all about. Same thing with some slogans. Without even seeing, we know who says finger licking good. Because over the years, you've heard that, right? You've also heard, I'm loving it. You've also heard, just do it. So we know what those slogans and who those slogans belong to. So this is basically the scope of the trademark. Now, in the United States, you're getting hungry. In the United States, you can use all of these things, and the minute you start to use it and people start to recognize it, you already have a trademark. So that's common law, right? Because it is synonymous with you, you already have a trademark. However, if you do need to protect your mark from infringement, and that is somebody else using your mark without your permission, you need to be able to go to court and say to the judge, oh, this is my mark. I've been using it for XYZ number of years. I've also registered it and somebody's trying to use it. I need them to stop or pay me money for loss and damages. For you to be able to do that, you have to register your mark. So think about it. Why is it necessary to register a mark? I know I just said it, but think about if you didn't register your mark and everybody is claiming that, oh, this mark belongs to me, what kind of issues do you think that will bring?
You have to protect your brand. If someone's imitating you and they get somebody hurt, but it's your brand, they're gonna blame you versus the person who tried to imitate you.
Okay, so wouldn't that mean that the courts would be inundated every single day? So if I didn't register my mark, for example, I could be sitting in my house and come up with Coca-Cola, and then Coca-Cola comes up and is using it, and I go to Coca-Cola and say, well, actually, I've been using it in my house. It's my mark, right? And so the courts would just be inundated with people claiming to be using stuff, right? Because somebody else is getting any kind of financial gain from it. So if you own it, you taught it, then you have to protect it. And how do you protect it? You go and register your mark. Okay.
Yes.
So the acquisition of a trademark is actually through genuine commercial use. So what that means is I can't have a mark, put it in my drawer in my house or in my office, not use it at all and think I've got a trademark. That defeats the purpose of it being used commercially. That defeats the purpose of trying to avoid consumer confusion because no consumer has seen it in the first place. So why would anybody be confused? So for you to have a genuine trademark, you have to use it. So that doesn't mean that you can think of something today and not register it. No, that's not what I'm saying. I'm saying you can think of something today, register it tomorrow, but you must use it. So you can't think of it today, register it tomorrow, and then not use it. It doesn't work that way, because then you're preventing somebody else who may have genuinely also thought about it and wanted to use it, right? So what the last time we had a case that went up all the way to the Supreme Court, one of the judges basically said, for you to have a mark, you have to have actual use rather than mere adoption. So it's not you saying, oh, I have the mark, I thought about it, I designed it. No, you actually have to use it. So that's basically what we're trying to say, that it's essential for you to have commercial use, for you to have and retain your mark. Okay, another quiz. Let's see who can identify these symbols. Who do these symbols belong to?
Good evening. One is Rolex, Audi, and Mercedes.
Oh, wow.
You have to put it in the chat.
And Jaguar. Oh, I'm sorry.
Oh my goodness, Kimmy. We're still thinking.
And then it wouldn't type.
Steph, you know I know that Mercedes. That's my dream car. I don't know nothing else.
I could only think of two of them anyway. Oh, now I get it, Jaguar. I don't know what that last one is.
Okay. I'm increasingly making it harder, by the way. Okay, has everyone finished writing? Some people are getting it all. Some people are going to win some prizes today. Okay. All right. I'm going to move on. I'm looking at the time. Okay. So we've been talking about, you thinking about it, you owning it, and you protecting it, right? Which invariably means that anything you think about, anything you own, you can protect as a trademark. Not quite. No, not really. So there's certain things that you cannot obtain a trademark on. So I'm just going to, this slide, I know we're going to, share it with everybody, but so I'm not just going to read from it, I'm going to actually talk to it. So think about it. We're trying to be a moral society, right? So if somebody gained a trademark by using offensive, vulgar language, that really wouldn't be very, very good for us as a society as a whole, right? So one of the things you cannot trademark is anything that is deemed offensive, vulgar, or contrary to public morality. You can't do that. Anything that is descriptive. For example, I'm going to use apple. The apple fruit is an apple. You cannot trademark that because it's a fruit. Everybody eats fruit, right? You can't trademark that. But Apple as a computer, when you think about it, what is the correlation between Apple and a laptop or Apple and a phone? There really isn't any. But because it has been used for so long, it has now gained secondary meaning and secondary use. Not that the computer or the phone is an Apple, but because that sign is used or that logo is used for that product or service, it has now gained that commercial use. So yes, you can trademark Apple as a computer, but you certainly cannot trademark Apple as a fruit apple. Nobody's going to give that to you. Similarly, if you had a cup, you wanted to trademark a cup, and you go and say, oh, I want to call my cup a cup. Well, no. Everybody uses a cup. It's a utility product. Everybody uses it. So if you trademark it, what's the rest of the God knows how many billion people on Earth supposed to do? So
I have a question.
Yeah.
Okay. Get some free legal advice here. So as you know, Sestra stands for sister, right, in Swahili, and now is Network of Women. So trademarking, we call each other Sestras. So the fact that we call each other Sestras in our organization, is that something that you would say, because it's sister, no, you cannot, like, or would we have to do it with now?
You have to
Sestras.
do it now. You can't do sestras because you first of all have to declare that sestras in Swahili means sisters.
Oh.
So you're going to have to declare that. But when you put the now, you can have a trademark as sestras now, but you can't have a trademark for sestras.
So anyone could call. Okay, got it. Thank
Yes.
you. Just thought I'd throw that in there. Haha.
Okay, and then in addition to that, anything that has a government insignia or a government symbol, you obviously can't trademark that because it doesn't belong to you, it belongs to the government. And I already talked about anything that's functional or any generic logo or any generic design that you can, for example, now go and trademark an apple because everybody knows who Apple belongs to. Hi, Kenny, you have a question?
Oh, hi, I have a question. So like the last slide, you talked about trademark that you have to be in business or have commercial transactions. So at what point should you get a trademark? Should you make your name a trademark? That's question number one. And then question number two is, what's the difference between a patent and a trademark then?
Okay, so a trademark, you can get a trademark today. Like I said, when you think it, you own it, you can trademark it today. But when you do that, you have to say it's intent for use. So the government, the USPTO would allow you put in your application and say, I intend to use this mark, or I intend to use this word, or I intend to use this sound or device or symbol, whatever it is. You say you intend to use it. By the time they've given you the mark, they're going to ask you to do a statement of use. And that statement of use is showing them that you've actually started using it. So they give you 6 months from the day your mark is registered to put in a statement of use. In that statement of use, you have to show evidence that you've actually been using the mark, the word, whatever it is. If you do not, it's canceled. So that's on that score. The difference between a trademark and a patent, with a patent, it has to be novel, it has to be unique, it has to be useful. But a trademark doesn't have to be any of those things. So it has to be useful means you invented something that is useful. It is unique. Nobody else has really done that before, right? But in a trademark, we're not saying that. We're basically saying it has to be used commercially. It has to be distinctive in such a way that that brand or that mark is associated with that brand and not with anything else. But it didn't say it had to be unique. It didn't say it had to be new. It didn't say it had to be invented. That's the difference.
All right, thank you.
Okay.
I'm scratching my head still, but
Yeah, isn't fried chicken though?
Sorry? Well,
don't mind me. Keep going.
yes, but think about it. When you say finger licking good, it's chicken, right? But if you do McDonald's or Kentucky Fried Chicken, you didn't just say chicken, you said Kentucky Fried Chicken. But then again, it's not the chicken that's been trademarked, it's the sign. The Kentucky Fried Chicken is a man. That's not chicken.
True. Okay.
All right. So I want to talk about the application process. So you've thought about it, you now own it, and now you want to protect it. What do you need to do? The first thing you need to understand is to register a trademark in the United States, at least you need to have an attorney do it for you. You can't do it yourself. That's the first thing.
Okay.
Then when you have decided what attorney is going to help you, the attorney puts in the application to the United States Patent and Trademark Office. And then you get something called either a response, in which case they tell you, yes, we've received your application, everything looks good, and we're ready to proceed. Or you get something called an office action, which invariably says there's something wrong with your application, or there's something wrong with what it is you're trying to trademark, and then you have to respond to it. After that, once you pass that hurdle, the next thing is that your proposed mark is then published. It is published because it's allowing other people come back to say, oh, hang on a minute, I already registered this mark. You can't give this mark to somebody else. Or this mark is so close to my own name that it is going to cause confusion, right? So this sounds like a lot of work. So once you pass that hurdle and nobody gives any kind of opposition, you now get something called a notice of allowance. So just like we were saying before, if you already started using your mark and you let the office know that you started using your mark, then you would not get a statement of use, because you did not register it with an intent to use, you registered it as a mark already in use. So if you registered it as an intent to use, you are definitely going to need to do a statement of use within 6 months, or else you lose your registration. After that, you do have to maintain your mark. I'm not going to go into all that because I already see some people complaining that it is a lot of work. But then you get a letter saying, congratulations, you do have a trademark. So that is the application process. Everything is done online these days. You can go and actually check as soon as the application is put in, it is public, it's for public viewing. You can see it. And then once it gets approved, you can see that it's approved, who owns it, which attorney did that. And then if you have not maintained it, or you haven't sent in your statement of use, you see that they will either say it's inactive or it's dead. So your trademark can die.
So I have a question. Did they change it recently that only attorneys can get a registered trademark?
No, it's always been that way.
Because I registered my own trademark without the use of an attorney. And I got I did. And I have my, I got the trademark. When I registered it, I had it. So they asked me those questions, if I, whatever. And yeah, I was able to get my trademark, and it shows that I'm the owner. Shows that I'm the owner. It shows that what it's used for. Huh?
Did you go directly to USPTO and register it, or you went through the company? Because
no,
now,
ma'am.
Now you have to use an attorney.
USPTO.
Oh, wow. Now you have to indicate the attorney's name on there.
Okay.
How was this? Because I don't know. I mean, recently, I know you can't. How long ago was this?
My trademark has been live for about maybe 4 years now. And it's for 10 years before I have to do any kind of
renewal. Yeah.
To maintain it or renew, to, like you said, you maintain it or whatever. Yeah, but I was able to do it and got my mark for my accessories, apparel and things like that. Yep.
Okay. I'll have to research that, but I know now you can't do that. It even says it there on the USPTO. So I have to research that. I don't know. But since I've been doing this for 4 years now, you have to have a US attorney do it for you. And you even have to register with your license and all of that. So I'll have to find out how that happened, but I don't know. So I don't want to say what I don't know, but I'll come back to you on that.
Got it. Thank you.
Right. All right. So we're just going to relax now because we're almost at the end, and we're just going to do some more quizzes and see if we can identify some of these additional marks. So this should be relatively easy. Do we want to try and see if we know who these belong to? This has to be very easy. Okay, I guess maybe we're getting a little bit tired. Do I move on to the next one?
Oh, I thought we had to type it, so I already did.
Oh, no. Yeah, you're typing. No, I'm waiting for
yeah.
people to type.
Okay.
I want to move on to the next one. So if you already know what you're going to type, if I move on to the next one, or wait for everyone to finish typing, that was what I meant. Okay. I think everyone's grabbed this one. Oops, did I go back? Sorry. What about these? These may be a bit challenging. I
Yeah,
think
those are challenging.
I think one should be relatively easy.
The only one I know is Toyota.
One should be relatively easy. The rest might be challenging.
Oh wait, I think I know the. Oh shoot, Cammy. All right now.
Do not Google. Okay.
Oops, I can't do this. Why can't I type?
And I deliberately did this one this way because I knew it might be a little bit challenging. But two, I think, should be fairly, people should fairly know, but two, possibly not. Because they're not really in the US. They're not a lot of.
Yeah, you got me.
Mm-mm.
I
All right.
probably want to own them though.
Y'all know these. Listen.
I mean, I can tell you they're all cars.
Yeah, we figured that.
Tell you they're all cars, but I know that
Oh, I know which
possibly
one.
one or two will be known here, but the other two might be a bit of a challenge. So this is where the rubber hits the road with who's going to win this competition. Okay, so what about this one?
Oh my goodness. Oh.
Again, most of them fairly known here in the United States. Some of them not so much.
I don't know.
Okay. Someone's getting 3 out of 4. That's like 3 out of 4. 3 out of
If
4.
the poll was working, this would be a lot easier because then we could at least pick
Just
from
click,
the list.
yeah. Yeah.
It's a good thing it didn't work.
Yeah, I'm disappointed in Zoom. I'm gonna complain.
Motorola was my first cell phone before Apple.
Raquel, you have to do message to all. You're doing it only to me. She's not going to see your
Oh.
answers.
Sorry. Uh-oh.
Okay.
Yeah.
Yeah. Not quite. Ericsson. Wow. That's from way, way back.
I was just guessing when someone said Motorola that is the V Ericsson.
Ericsson.
Isn't it Verizon? Yeah, it's Verizon.
Oh,
Apple.
wow.
Okay, I'm gonna go to the next one, which will be easier. This should be
Okay,
easy.
let's get this one.
This should be
Okay, I
easy.
got that one.
That's good.
I think. I don't know what that last one is.
Which one? The left or the right?
The red one. Oh, okay. I think somebody just gave. Okay, I can't. It's okay. I can't win anyway.
It doesn't mean I exercise.
What is that red one? Mm-mm. Mm-mm.
What everybody would know.
Mm-mm.
Okay, if you do yoga, you will.
You will.
Right. This is so fun.
Okay. So now, if there are any more questions, feel free to ask me. And we literally almost used the whole hour and it didn't feel like it. So you guys have been a
Yes.
wonderful,
have-
wonderful audience.
I have a statement. I have been fighting with USPTO for 3 years about trademarking my company name, and I could not understand why this examiner was giving me such a hard time. But after hearing this tonight, now I
Yes.
understand what the problem was.
Oh, I'm
So
so
thank you
happy.
for that,
I'm so happy. I'm glad I was able
because
to
I was
help.
ready to strangle this woman.
Don't strangle her.
Don't strangle the lady.
Do you want to stop share, Ida, so they can see you?
I just wanted to basically,
Oh,
if you
okay.
understand that, or anything, we have to do the whole spiel thing. And then I'm gonna stop share because this is
So,
gonna be.
so via Sestranel Consulting, you can have, take advantage of Ida's services at, more affordable price. So just so you know, Sestranel Consulting is how we provide professional services. As you know, on the app, we have all women business owners. If you're a business owner, you definitely want to get on the app, but we separate our professionals like Ida and offer their services through Sestranel Consulting. So if anyone is interested, please contact me or go to sestranelconsulting.com to sign up, and I will be there to help oversee the whole process, okay, and ensure you get that Sestra discount. But we want to thank Ida Ivowi for her wonderful presentation tonight. And yes, it was an hour, but it was a very quick hour.
Yeah.
And
Quick
that was
question.
amazing. Go ahead.
Is Ida or no?
Sorry?
Are you
Reasons.
I'm
You
sorry.
freezing, Carmen.
okay. I
Okay. You can send me a message. That's absolutely fine. I'll answer the question. I am going to send the winner because I have to get this poll sent over to me, and then I'm going to definitely announce the winner. But what you're going to win, in addition to the discounts, is you're going to win a free consultation with me, or if you do decide that you want to have a trademark. And basically what we do is we make sure that we send you a trademark memo. We do all of the necessary due diligence for you, because another thing I did not quite mention is that even if you have a name that sounds or is quite similar to somebody else's name, there's a possibility that you would not get the trademark because, again, the confusion, right? Just like Vanessa was saying, they're not letting her use her name. I don't know what the story is behind there. It could be maybe it's one of the words that are not allowed to be used. Maybe it's too descriptive, or maybe it's functional, or maybe it's too close to somebody else's mark. So we do that due diligence for you. We make sure we come back to you and we checked, and then we tell you, even if you're not going to get this, maybe if you add a word or you add a phrase or something, you're able to get your mark. And we take you through the whole process.
Carmen asked, are you in the United States?
Yes, I am.
Yes. I met her in Queens at a bar association event in Queens. So I know she just travels a lot through different countries.
That's true. But
okay.
I am.
So, Ida, if you're done, we're going to wrap this up at 1 hour. And I just want to thank everyone for coming out and attending. This will be available on Sestronow's YouTube channel. Again, TELOSLEX is available on our marketplace and also through sestronowconsulting.com. So we thank everyone for joining us. And for those that are watching the recording, please feel free to reach out to us and make sure you download that sister app at www.sestronow.com. All right. Good night, everyone.
Good night.
Good night.
Bye.
Good night.